Hi, everyone. All right, so let's officially start. Okay, hi, everyone, again. Um, so thank you all, first of all, for being really patient with us. Crowdcast really did, it was cooked, but, we have Zoom as a backup. So thank you guys for staying on that long and also doing a bit of the Cram Quiz with us. So we're going to reintroduce ourselves for like the third time, and hopefully it stays together. So once again, I'm Amara. I'm a senior in high school, so this is my last year of taking APs, and I was once in your shoes in sophomore year. So I'm excited to be back with AP Gov.
Hi guys, I'm Kayla. I currently attend the University of California, Los Angeles, aka UCLA, as a college freshman, and I'm excited to go through night one with you guys.
Hey everyone, I'm Sandra. I'm a student at George Washington University studying political science. So I really liked AP Gov when I took it, and I'm really excited to be it now.
Sorry. Okay, hi everyone. My name is Demi. I'm a senior in high school. And I was in your shoes last year because I took the exam last year. So I'm excited to share what I know and get to learn more from you guys.
Hi everyone, my name is Daniela. You can call me Danny. I took AP Gov last year and I'm currently a junior in high school. And clearly we got through this little crowdcast issue together. So I'm really excited to get through night one with you guys.
All right. So far, so good. No issues. All right. So, Demi, if we can move on to the next slide. All right. So, first of all, follow Fiveable on social media, guys. All right. This is how you guys can also get a lot of information quickly because I know that, people our age are always on social media. So, if you guys are on Instagram or TikTok or anything like that, Fiveable has an account. So, if you guys follow it, you guys will be able to get information a lot quicker, either about AP season or just anything really fun AP related. All right. Next slide. So today we're going to go over quickly an overview of the multiple choice questions, then the foundational documents and the SCOTUS cases that you guys need to know for this exam. And then we'll dive into Unit 1 for the foundations of American democracy, have some discussion questions, and then some practice questions, which you guys already got a preview of. All right. So as always, we just want you guys to be supportive, be patient with each other, and also be kind to each other. You guys have really done, the second bullet on being patient. So, we love to see that. But just be kind to each other in the chat and also just be supportive with each other because we have 5 nights together. So we really want to get through this as efficiently as possible. All right, next slide. So 4 things to note. 1, you guys can take notes, all right? This is like if you like to write down things on pen and paper or on any sort of device that you may have, notes are going to be your best friend. You can use them to write down the mnemonics that you might use in order to remember, let's say, like the Federalist Papers. Any questions that you may have for yourself, or if you do have questions for us, you can always do the Q&A that's at the bottom of your screen or just in the chat, and we'll try and answer as best as we can. The My Stuff, you guys will be able to find that in your fileable library. That has all the slides for every AP that you guys signed up for Cram Mode, the review packets if there are any, and the replays, though I don't know how that's going to go now that Crowdcast has, stop working for us, but we'll see how that works. Group chat, now since we're on Zoom, you guys will be able to chat with each other in the chat. So, just participate whenever you ask questions if you can, and also just ask each other questions as well. The Q&A tab will actually be at the bottom of your screen now. It'll say Q&A, and some of you guys actually found that function, a couple minutes beforehand. So just be sure that if you have a question that's really big that you really want answered, put it in there and we'll try our best to check. All right, next question or next slide. So throughout the 5 days, we'll be going over Unit 0 and 1 today, along with multiple choice. Tomorrow, Unit 2 and concept application. May 3rd, Unit 3 and SCOTUS. May 4th, Unit 4 and quantitative analysis. And then May 5 is your finale. So that's Unit 5 and the argument essay. All right. So quick overview of the multiple choice and really of the exam in general. So there are 55 multiple choice questions and you have an hour and 20 minutes to get through them. All right. So this is 50% of your score. This means that you have about a minute and some seconds per question. So really manage your time on this. If you can take practice exams, take them and try and, just practice the times. For the FRQ, you have 4 questions, an hour and 40 minutes to answer all 4 of them. Question 1 is the concept application question. Question 2 is the quantitative analysis with data. Question 3 is the SCOTUS comparison, and question 4 is argument essay. All right, so these are the 4 questions that get answered on your FRQ, and we'll go into that throughout this whole finale season. So the units are broken down by grade weight, but the main 3 that you guys should really focus on are units 2, unit 1, and unit 5. All right, so we'll try and go in depth through all 5 of these units actually, but those are really the 3 that I would suggest you focus on the most. All right, next slide. All right, and these are the 3 types of multiple choice questions that you'll find. Standalone questions are basically talking about different concepts. So if they ask, which of these was a principle in Federalist number 51? That's a standalone question, right? That's just like eliminate the wrong answers and, circle the correct answer. Graphic-based questions are graphs or like, different charts, and they'll ask you a question about the graph, and then you'll have to answer the question. These are always multiple choice questions. So just look for an answer that has to do with the graph, and then you'll probably be fine. And then the passage-based questions are a bit longer. Some tips from different students are to look at the author and the time period first in order to get some context, and to annotate the really important stuff that you need. So if they're talking about like a certain case, you underline that. If it's just talking about like, I don't know, like dogs or something, and it has nothing to do with the question, cross it out, don't look back. All right, so we're gonna do a minute to answer this question. You guys can actually put the answer in chat. But which of the following is argued by James Madison in the Federalist paper number 10? Okay, seems like a lot of you guys actually get this. So, okay, so Demi, we can actually move on to the answer.
Oh my God.
It's okay. Yep, so you guys are correct. It's A. So Federalist 10 has to do with factions, and I'll actually go over what those, all the Federalists actually go over. But you guys are doing really well so far, so you guys aren't cooked. All right, next question, next slide. So unit 0, let's go. So required foundational documents and Supreme Court cases. So the first one is the Declaration of Independence. Now, if you guys have taken AP Gov, which you have since September, hopefully, you guys would know about this. So this was written by Jefferson, and it included 3 ideas: natural rights, popular sovereignty, and social contract, all right? So the natural rights are life, liberty, and the pursuit of happiness. And these are the rights that the government cannot take away, all right? So Jefferson wrote this, and he was like, these natural rights, we have them. You as the government, talking to King George as Britain, you can't take them away, all right? Popular sovereignty has to do with the power of the government given by the people, all right? So the people give the government the power to become the government. The government doesn't give themselves the power, all right? So that's really the main difference between what King George did to the colonists and what popular sovereignty is, which is what the colonists wanted. And then you have a social contract, which is where people will give up some power so that the government can function. So it's like saying, I'll give up my power to say that Thursdays are pizza days to the government, right? I know it's not that simple, but that's really the idea of it. And through these 3 different ideas, it came to like a conclusion that people have the right to change or abolish a government if their natural rights are violated. So this meant if someone's life, liberty, and or pursuit of happiness is violated, they have the right to change or abolish the government that they gave power to. So then in the second portion of the Declaration of Independence, the grievances were listed against King George. So this is taxation without representation, unfair quartering of soldiers, and other things like that that you've learned in other history classes. And then the third one was just the resolution for independence. This is where the colonists were like, we are done with Britain, we are breaking up. And then now we move into the Articles of Confederation, all right? So I'm just gonna call these articles for sake of time, or AOC, right? So this is the first constitution that created a government for the US post Declaration of Independence, all right? So this was made so that the colonists actually had a, government to go off of and some sort of document to go off of. However, even though they had things in there that, they wanted, they weren't as strong. So one of the key details that you should remember about the articles is that there was very limited national power. This meant that states had more power than the federal government, even though the federal government did exist. You can think of it like if you guys know about like paper companies or something like that, it's like a fake company. The federal government is like kind of fake at this point in time, where the states have all the power as if they were the federal government. They only had one singular legislative branch. There was no president or court, and Congress representation was the same in large and small states. This meant that Virginia had the same amount of representatives and representation in Congress as, let's say, Rhode Island. And this is how you get through like different, the Virginia plan, New Jersey plan, that sort of thing, but you don't need to know that right now. And then last but not least, any amendments that were to be made to the articles needed all 13 states to agree on it. If one state decided not to, that amendment wouldn't hold and it wouldn't be passed. So key detail of the articles: limited national power, states had more power than the federal government. All right. So now we have the birth of the Constitution, okay? So this outlines the structuring function of the government that we have today, and there are two parts that you need to know. First, Bill of Rights. Those are the first 10 amendments of the Constitution. I'm gonna warn you now, if you don't know any of these 10, like any of them, you need to do some studying, okay? So we're gonna go over that like, in the next slide and everything, but you have to know all 10 amendments, the first 10, all right? The other amendments, the other 17, aren't as important for memorization, but you should know, like, the 14th Amendment that has to do with due process, equal protection under the law, things like that. And then there's some like small ones, like what amendment lowered the voting age to like 18. Those small amendments are good to know, but they're not required for you, as in like, you're going to be tested on like, what's the like, I don't know, 15th Amendment about? No, they're going to ask you, what's the Second Amendment about? What's the Fourth Amendment about? What's the Fifth? Things like that. So know your Bill of Rights and look over the other amendments as well if you can. All right, next slide. So the Bill of Rights. I'm going to go through this a bit quickly, but if you have any questions, be sure to let me know, let us know, and we'll try and answer it as we go. First Amendment, freedom of religion, assembly, press, petition, and speech. So there are a lot of SCOTUS cases that have to do with that, but within the First Amendment, you'll hear things like the Establishment Clause. That has to do with the freedom of religion. So does the freedom of expression. I will go slower, sorry about that. So the Establishment Clause says that there's a separation between church and state. All right. So if you guys can actually give me the SCOTUS case that has to do with that, that would be awesome. So you guys can remember that. So Establishment Clause, separation between church and state. Federal government cannot endorse a religion or anything of that nature, right? So Anglo Vital is the one. And then you also have the Free Exercise Clause that has to do with Wisconsin v. Yoder, which is, you can express your religion in any way possible, so long as it's within the limits of the First Amendment. Second Amendment, right to bear arms, that's really it. McDonald v. Chicago, that's the case you want to know. Third Amendment, right to not quarter soldiers. There really aren't any cases about this. It's just, a contrast to what the colonists had to do pre-Declaration of Independence. Fourth Amendment, freedom from unreasonable search and seizure. I can't remember if there's a required case for this, but it basically says that the police must have a warrant. And yes, Lopez can be Second Amendment. Fourth Amendment says that the police have to have a court ordered warrant in order to search and seize, or they have to have some sort of like a reasonable, idea and concept as to why they need to search and seize at that moment without a warrant. Fifth Amendment protects from self-incrimination. I believe we've all heard of I plead the fifth. That's basically saying I'm going to prevent myself from incriminating myself. So I'm not going to answer this question or, make true the statement. It also provides due process of law, which does tie in with the 6th and the 7th Amendment, as well as the 14th. And this basically says, going off of the 6th and the 7th, is that, your trial can be fair, impartial, and speedy, that you can have a jury that under, the laws of being like a criminal or being like, arrested for some sort of like criminal act, you have certain procedures that you have to follow, and that under due process, that those procedures should be followed accordingly, right? So under the 6th Amendment, the right to a fair, impartial, and speedy trial, you cannot be held basically in jail for 2 months without knowing what you did, all right? So that's unfair. Impartial is where it goes into also the trial by jury. And that's where you'll have a jury made up of your own peers. So this means that if I'm a, I don't know, like federal agent or something, and I'm on court and I have a jury, it's not going to be made up of all like, federal or not really, or like police officers or something. It's going to be like mixed up so that there's no bias within that jury against me or something like that. And speedy, it's just reasonable. It's not too quick and it's not too slow. Seventh Amendment, I already said, trial by jury, it's made up of your peers. Eighth Amendment, no cruel or unusual punishment. This has to do with certain cases where to a certain person, let's say a person is like, mentally ill or something else like that, that in the case of, let's say, the death penalty, that might be seen as cruel and or unusual. So under the Eighth Amendment, that can't be used and some other form of punishment might be used. Ninth Amendment says that people are still granted rights not listed in the Constitution. This I will also talk about when I talk about the Federalist Papers a bit. That's also a very important thing to note. And then the 10th Amendment says that the federal government only has the rights given by the Constitution. So within the Articles 1, 2, and 3, 4, 5, 6, 7, everything like that, up until this 10th Amendment, or really until the end of the Constitution, any rights given to the federal government is given to them. Anything that's not is reserved to the states and the people. So far, are we okay with all this? Yes, yes, good. All right. So federal versus state power. So there's some overlap, but there are also some very distinct differences. So federal government or the federal powers are making treaties, so the federal government can make a treaty with, let's say, like Botswana or something. The state of Virginia can't. The federal government can regulate the postal system. So this means like, looking over the rates, looking over what states, how the lines are going to happen, communication, things like that. They can declare war. This is really great in my opinion. I don't want my state to declare war. I don't know if that's just me, but I think that's a good idea to have just the federal government having that power. The federal government can also regulate commerce. This is mainly interstate commerce, which is basically along state lines. So from Virginia to, let's say, Massachusetts, don't ask me why I keep using Virginia. That's interstate commerce. If I like send a package to someone in Virginia from Massachusetts, that's interstate commerce. However, if I send it and I'm in Boston to someone in Bridgewater, that's intrastate. That's not necessarily the commerce that Congress is responsible for. They're mainly responsible for the ones that go over state lines or going over borders. State powers establish local government. That's why, every state has its own, not every state, every small county or so, or small town has its own local government. Public schools, conducting elections. So if you guys have registered to vote, if you are of age to register to vote, you might have gotten a ballot for mail-in voting. I know I did, where you can either check off for a certain ballot and whether you're going to do local elections. And that's for, who's the governor of your state, who's going to be the state representative, things like that. So those are also important elections other than the national election that's happening in November. And also it's another state power protecting community health. This is just establishing hospitals, ambulances, law enforcement agencies, things like that. Shared powers. Go back, sorry. Shared powers, there are three main ones: collecting taxes, regulating banks, and making and enforcing laws. So those ones are shared among the federal and state government, and they're seen in different ways. All right, let's move on. So Federalist and Anti-Federalist Writings. I will get through the other questions that you guys have about the amendments in 1 second. But for the first Anti-Federalist paper, Brutus number 1, this argued against the ratification of the Constitution. All right, so remember, context-wise, this is after the colonists departed from Britain. So the Anti-Federalist, or Brutus, argued that a confederacy under the Articles, where there's more state power, is better than a republic from a constitution. All right, so having more state power was better than having a federal government. And this was because they feared that the federal government had too much power to crush states with the necessary and proper clause and the supremacy clause. So the necessary and proper clause basically states, and it's really applying to Congress, is able to pass reasonable laws, all right, that are necessary and proper in order for them to really carry out their responsibilities and enumerated powers from the Constitution. So if Congress has the power of the purse, they can, under the necessary and proper clause, establish a national bank, right? That's applicable under the necessary and proper clause. Supremacy clause says that federal law trumps state law whenever there's a conflict, all right? So the Constitution, federal law, and treaties trumps state laws whenever there's a conflict. So if, sorry about that again. So if the federal government decides that, and let's say like this is within their power to make Tuesdays like Taco Tuesdays or something, but then like, the states are like, no, we want it to be Wednesdays. Under that, federal law would triumph. I know it's kind of silly and it doesn't really make sense constitutional wise, but that's really the general idea of it. And the Anti-Federalists argued that there's not enough checks and balances to limit the federal government in court, creating legislation and collecting taxes. So they were really worried that there would just be one body, one like legislative or like one federal body that had all of the power that has to do with creating legislation, being the courts, and also collecting taxes. And then they basically just said that the Constitution lacks the liberties such as the freedom of speech, religion, and press, right? So you know how I said before how the 9th Amendment was a thing where that the Bill of Rights weren't all of the rights given to the people, that there was still some that, you could imply and that, the people still had. That amendment and really the entirety of the Bill of Rights was made in order of this point. The Bill of Rights was made so that one, the Federalists could actually sign the Constitution, and two, so that people actually knew that they did have freedoms such as speech, religion, and press, that they didn't have to quarter soldiers and things like that. But the Federalists knew that there wasn't enough space to write out every single possible right that people had. So the 9th Amendment is in place to say that, yes, these are, the rights that you have, but there's still other ones that you do have. All right, and now the 4 Federalist papers that you absolutely need to know and understand, unless really you can't answer that last FRQ question. So Federalist 10, as you guys said beforehand, has to argue about the centralized government and protecting liberty, and that'll protect against violence from factions, okay? So Madison talked about factions, how he was like, there's always violence, but if we have a centralized government, which we have now, it can protect liberty, and that also can be, made possible through like political participation and things like that. Federalist number 51, checks and balances. You guys also know that. So I don't know why you guys keep saying you guys don't know these things. You do. And it advocates for a separation of power. Okay, so the fact that we have the executive, judicial, and legislative branch, those all fall from the Federalist number 51. All right. Federalist number 70, an energetic and forceful president. All right, that we need a president like that in order to stabilize the government. And Hamilton wrote this, and he basically described what a good president is like. So I urge you guys to read that document so you have all the characteristics, but essentially this is the main idea, that a president who's energetic, who's forceful, who's, stable, and who has the people's interest in mind is the best president. And then Federalist number 78, judicial review. So if you guys know Marbury versus Madison, which we will be going over also later today by one of our other hosts, judicial review was introduced by Federalist number 78. So this showed the importance of consistency within the Constitution, and the Federalists and really the framers didn't really want the Constitution just to be another document under a pile of like 30,000. They really wanted it to be, this is the law of the land. We want it to be followed from now until, the end of time or something like that. So advocated for the judicial branch and the role of judges in carrying out duties and independence, basically saying that laws should be in line with the Constitution, that anything that's outside of it should, be judged and should follow the line of the Constitution. All right, so far, so good. So letter from a Birmingham jail. I believe this is the very last document that you guys need to know about. It was written by MLK while he was in jail in 1963. So we can move 2 clicks just so I can have the information. Yep. All right. So the first point that MLK brought up was the nature of segregation. He wrote to disassociate the separation between the ideologies in separation of segregation. So he was basically, laying down the foundation that, hey, segregation is a thing. I don't know if you guys know that, but segregation is a really big thing. And through that, he then goes in about his hope for the future. And he talks about how America's goal is freedom, And, it's kind of ironic how there's segregation, but, America's still promoting this freedom concept. So King ultimately wants the division to be dissolved, that whole entirety of segregation to be dissolved, and for the recognition of all peoples. And he basically called for a time for change where he demanded change amongst the people, all right, not just in Birmingham, but across America. And he said that no one should have to wait to be given rights. So in his letter, he basically made the statement that people had argued that, oh, you guys should wait like a year or two, and then maybe your rights will come about. King is like, no, we don't have to wait. I think we can do this now, right? And that's where you get the concept of civil disobedience, which is where it's morally okay and correct for you to disobey an evil law. Under King's eyes, the evil law was any law that was advocating for segregation. So follow every other law, but the ones that advocate for segregation and things like that. All right. So Demi, I will give this to you, and then you will start on SCOTUS cases.
Hi, everyone. Can you hear me? Okay, I'm gonna guess that you can hear me. Yeah, great. That's great to hear. So now we're gonna go over all the required cases that you need to know, like all the Supreme Court cases. So the first, like what we're doing is grouping them into categories. So the first is the powers of the federal government, the issue of federalism and balancing that. The first case is Marbury versus Madison. This case strengthened the role of the judicial branch of the government and also affirmed the principle of judicial review. So basically, just for like some context, Marbury was this guy appointed by John Adams. And John Adams, like he was kind of irritated that Jefferson was going to be president after him. So he just put together like all these court systems, stuff like that, appointed all these people to be in power that kind of had his values still there. And so basically, even though all these people were appointed, they needed to be commissioned by the Secretary of State. And even though once Jefferson got there, Marbury was still there, but he didn't have the commission from the Secretary of State. And so then this established judicial review because it went to the Supreme Court and they were like, oh, you don't have the necessary like documents or commission from the Secretary of State. So it established that that they can determine what is right and what's not. So it shows a check and balances because the executive branch doesn't have all the power here. Supreme Court judicial branch has power as well. So it set up the Supreme Court of the United States and it declared the ability of the court to interpret the Constitution. The next one is McCulloch v. Maryland. This is another case about federalism. Basically, in this case, McCulloch, there was the Second Bank of the United States, and Maryland wanted to hinder like the operations of the bank. So they were like, oh, we're gonna impose a tax because you're not chartered by the state. And they basically it went to the Supreme Court, and under the necessary and proper clause, it gave Congress the power to make laws. It basically argued that creating a national bank is an implied power of Congress, and that when it established the supremacy clause because it basically said that when it's between the federal government's rights and states' rights, the federal government is going to win in this case. So it said, oh, the states can't tax the federal government, and the federal government has the right and implied power to set up this bank. The next case is United States v. Lopez. Basically, in this case, there was a high school student in Texas who brought a gun. Well, he had a concealed weapon. And he was tried, convicted, sentenced to 6 months in prison. And basically, this case ruled that gun possession is not significantly impacting educational environment. So they can't base a law prohibiting possession through the Commerce Clause. Because the Commerce Clause basically gave Congress the power to regulate commerce among the states. And they said, oh, well, this exceeds Congress's power. So it would not be, they can't base a law. So the next set of cases are the First Amendment, freedom of speech. So the first one is Schneck versus United States. Basically, in World War I, Schneck was charged for mailing like these kind of pamphlets saying like, well, they're kind of critical of the US government and the draft. And so then he was charged by the US government under the Espionage Act for circulating these. And the Supreme Court, they upheld the conviction, and they ruled that the Espionage Act does not conflict with the First Amendment. Because basically he was saying like, you're taking away my First Amendment rights because you're not allowing me to circulate these pamphlets around. And basically invented the clear and present danger test to determine the violation of the First Amendment. So basically they were saying that, oh, because you're circling this around and saying, oh, you guys shouldn't go to the draft, this is a clear and present danger because we need people going to the draft and we need to build this army for the war. So because of that, he was convicted. And yeah, it limits the First Amendment rights against direct threats. So it shows that there are limits on your First Amendment rights. You're not just able to do whatever you want. And if they sense that there's a danger, a clear and present danger, then they can limit your freedom of expression. This is one of my favorite cases because I'm involved in like youth organizing and stuff. And this case basically, it solidified students' rights at school because, you know, school and jail, and the workplace kind of are places where your rights are limited. Basically in 1969, there was a lot of turmoil over the Vietnam War, a lot of protests about it. And these students, I think about 3 students, they organized a silent protest and they decided to wear Black armbands to school. And they were suspended for this. And a 7-2 court decision found that the First Amendment applied to public school as well. So this basically means they have freedom of expression in school. You can't suspend them just because they were silently protesting. It ruled that public school officials cannot censor speech unless it's disrupting the educational environment. And because they weren't disrupting anybody, they were just wearing the Black armbands in silent protest, they were not suspended. The next case about freedom of speech is New York Times versus the United States, 1971. So basically, Daniel Ellsberg, he leaked the Pentagon Papers into the New York Times, which included incorrect information regarding the Vietnam War, and he was sued for violating the Espionage Act. So in a 6-3 ruling in favor of the New York Times, it stated that the government did not overcome heavy presumption against prior restraint. So basically, in this case, you know, the Pentagon Papers, they were published by the New York Times about the involvement of the US in Vietnam. Well, and you know, the Vietnam War was heavily criticized. And basically oh my gosh, the Nixon administration, they didn't want this going around. They didn't want this kind of criticism. So they tried to like limit the First Amendment rights and the ability of the press to say things about this issue. And they argued that it would harm national security. So basically the Supreme Court ruled in favor of the newspapers and said that the US, like, you can't try to restrict this kind of freedom of speech. The press has a right to say something. And the White House is overstepping its bounds in this case. So it made it possible for the newspaper to publish information that's not directly harmful to the government or military. Citizens United versus the Federal Election Commission. This is all about like campaign finance and campaign laws. So in 2010, Americans disagreed about the extent to which fundraising and spending on election campaigns should be limited by law. So because of a special provision, Citizens United was allowed to appeal the case directly to SCOTUS. But just for context, Citizens United, they were this group that, well, they were this conservative group, and Hillary Clinton had been running for election, like to become president. So they released this documentary and they were like, oh, well, they were just saying all these bad things about Hillary Clinton and kind of like trashing her in the documentary. And so the Federal Election Commission was like, oh, you can't say that because they were using the money they got from the film like for like to benefit their campaign. And so the central issue was whether like these campaign finance laws violated the First Amendment protection of speech, because they were saying, oh, like we're allowed to say what we want in this documentary. You can't stop that from happening. But because of the finance aspect of it and the fact that they were profiting off of it was where the issue came in. So basically it the 5-4 ruling, it ruled that the First Amendment prohibits limits on funding of independent broadcasts in elections, and it was not persuasive enough to restrict political speech. But basically, political spending by corporations, associations, and labor unions is protected. And basically, also in this case, it basically solidified this idea that corporations are like individuals who have rights, kind of, that can be protected. So, so one of the big criticisms of this case is that it's giving corporations too much power, and that like they have too much of a voice in politics, and that's why you see the amount of money in campaigns like rising up and up and up, like millions and billions of dollars spent on these campaigns, because there's less of a limit on what can be funded here. So yeah. And also it led to like the creation of super PACs and more independent like groups who are putting in money and fundraising for politicians. The next section of Supreme Court cases is the First Amendment, freedom of religion. So Engel v. Vitale, 1962, it was a case that presented the question of whether public schools could sanction classroom prayers. I think it was in New York, and basically there was, well, every day, every morning, the kids had to recite a prayer. It was called like Almighty God prayer, to, I think it was like to promote moral values and spiritual guidance. But basically there's a separation of church and state, obviously, and the state and the government cannot promote a religion. So this was ruled unconstitutional because it violated the Establishment Clause. Wisconsin v. Yoder. This is one of my favorites. I feel like it's one of the most memorable for sure. So basically in Wisconsin, there were these kids, well, Amish kids, because in the Amish religion, well, actually, I can't say generally about the religion, but there was a family and they refused to send their kids to school. And Wisconsin, well, obviously they had a law that said, oh, all kids of this age must go to school. Sorry, I don't know what just happened. Okay, my bad. Sorry. Basically it said that I lost my train of thought. Okay, Wisconsin v. Yoder. Basically this Amish family, they didn't want to send their kids to school. And so, well, there was a law saying that you have to send your kids to school, but then Supreme Court steps in, they say, oh, because of religion, you are allowed to, like, I don't know how to phrase this right, but there's a protection of free exercise, basically, of religion. So in this case, like the religion trumps the state law because the free exercise clause, basically. The next section, equal protection of the 14th Amendment. So Brown v. Board, you all should know that. 1954, basically, you know, Jim Crow era segregation, Black children, white children cannot go to the same schools. But in Brown v. Board, basically the Supreme Court said that this is, well, there's the whole separate but equal. Obviously it was unequal, and it's decided that the state sanctioned segregation was a violation of the Constitution. It provided equality among education across the country, and it promoted the idea that diverse students thrive better when they learn together. Baker v. Carr is the next one. Basically in 1962, Baker sued the federal district's court, and he claimed that the law requiring the state to redraw their district, to make each district representation fair. So it established the right of federal courts to review redistricting issues or political questions. And they ruled in favor of Baker that the state acted unconstitutionally by not redistricting, violating the one person, one vote principle. Basically, just for more context, rural areas, which had less people, and urban areas, which had more people, had the same, like, each area had the same weight in terms of like voting, like they had the same amount of representation, which is kind of equal. If there's 10 people here and there's 200 here and they both have like one person, it's like, oh, that's not right. So they ruled in favor of Baker that the state acted unconstitutionally by not redistricting to make it more equal. And this enabled federal courts to hear redistricting cases. Shavi Reno was a reapportionment plan created in North Carolina, which making many majority minority districts where a racial minority is the majority. So basically, this is another one about redrawing the lines, because they redrew a line to make they were under pressure about not having enough like representation for minority communities, and so they redrew the line um to help with that. And then yeah, Supreme Court. So the issue was racial gerrymandering violates the 14th Amendment Equal Protection Clause, and the result is it violated the 14th Amendment because the district lines were too bizarre. Because basically it was kind of like this long, like oddly shaped, like very obviously like redrawn line. And it showed that the impact was that race could not be a sole factor in redistricting and became inspected more strictly. The next one is federalism through court decisions. So next one is Gideon v. Wainwright. Basically in 1963, Gideon was charged with breaking and entering into a pool hall, but he was denied a request for an attorney. So because he couldn't afford to have legal counsel. But the court ruled unanimously in favor of him, agreeing that guaranteeing the right to legal counsel, because everyone deserves to be represented in court, and to have their day in court. And it's not fair for someone to have to represent themselves because they can't afford to have a lawyer. So yeah, Sixth Amendment. The next case is McDonald v. Chicago. Basically, McDonald filed a suit against the city. Well, a resident of Chicago, he filed a suit against the city stating that the new gun control laws were violating his Second Amendment rights. Because the city had like this handgun ban, and they had stricter gun control regulations for public safety reasons. And the Supreme Court ruled that the right to possess a gun in the home is protected under the Second Amendment and the Due Process Clause. And so basically, this was like an kind of a debate between what are the limits between public safety, because obviously you want to make sure that everyone's protected. And as you know, like gun control is a big topic because mass shootings are rampant. So the balance between that and also making sure that people's rights are protected and their Second Amendment right to have a gun and to protect themselves is protected. So these are the discussion questions. In what ways do Federalist Papers number 10 and 51 justify the structure of government established by the US Constitution? So I'm going to give you a minute to answer that. Okay, I'm gonna go ahead and I'm seeing some responses in the chat. Basically, Federalist number 10, the way I remembered it when I took it is like factions, like 10, like faction, where the I and the O is. I just put 10 there and I was like, oh, I remember that. Basically it discusses how the Constitution structure counters dangers of political factions by spreading power, and so it prevents any single group from dominating, also protects minority rights. So the dangers of factions, and that justifies the structure of government. And then 51 is about separate branches. The way I remember that is just because 5 and 1 are different numbers. I know that's pretty bad, but like different branches, separate branches. Um, and so checks and balances prevent tyranny, and checks and balances kind of ensure the democracy that they came to the US to create. So each branch has the ability to check the other branches and ensure that no one branch remains the most powerful or becomes too powerful. So that's how both of them justify the structure. Oh, 5 minus 1 equals 4. Okay, I see. Separation of powers. The next question is, how did the Supreme Court's interpretation of the 14th Amendment impact the balance of federalism in the 20th century? Okay, I'm seeing some answers in the chat. Yeah, so basically about individual rights, because the 14th Amendment um, guaranteed more rights. And then what the federal government established, like the rights established by, like, all the states had to take that on. So Brown v. Board, all these cases that we talked about, all the states were required to like desegregation, all of them are required to desegregate, and it shows the balance of federalism. And like their interpretation of like the Commerce Clause or the federal authority of like the different departments, like interstate commerce, environmental protection, civil rights. Well, like as federal power has expanded, all the states kind of have to take on those laws and those regulations. Yeah, I really like some of the responses I'm seeing in the chat. Absolutely. Yeah, basically, yeah, the states couldn't infringe on individual liberties or individual rights that were established by the federal government. The next question is, explain how landmark Supreme Court cases have balanced individual liberties with national security. Yeah, I like the answers I've seen in the chat about New York Times Co. versus the US, with the power of the press. Schnuck, yeah, Schnuck v. US. McDonald v. Chicago, yeah, because that protected the individual Second Amendment rights versus national security. And if you even think about like the Patriot Act and surveillance law too, and how that prioritizes national security over individual liberty. Um, yeah, yeah, you guys got this in the chat for sure. When I think about this question, I also always think about like surveillance law, um, and just how, the government's always watching us, and just how like the breaches on the breaches on individual liberties in order to protect national security, especially after 9/11. And so next up we have some practice MC. So this is the first question. All of the following were concerns about the Articles of Confederation. Oh my gosh, sorry. All of the following were concerns about the Articles of Confederation that led to the calling of the Constitutional Convention of 1787, except A, dissatisfaction over safeguards of individual rights and liberties, B, fear for the stability of the central government, C, desire to promote trade among the states, D, the need to give the central government the power to levy taxes, or E, dissatisfaction within the central government's ability to provide for national defense. I'm seeing lots of A's and B's. Oh, I see C too. So which one were concerns? Which one was not a concern, except, like, remember that, underline. Okay, I see elimination. So I'm seeing definitely not E or D. So we're stuck between A, B, and C. Oh, the answer is A. Dissatisfaction over safeguards of individual rights and liberties. That was not one of the the big concerns that led to the calling of the Constitutional Convention. Like fear for the stability of the central government was not, well, I mean, I don't think, I'm just saying, wait, oh wait, that accepts, remember that. So this was not one of the concerns that led to the calling of the Constitutional Convention. The rest of them were concerns, and that led to the calling of it. Well, because each state kind of had their own laws and their own little country in a way, like their own way of governing. So desire to promote trade among them and to kind of centralize that power, like the central government power. That's why I don't think it would be C. That's why I don't think it'd be C. Because I think A fits more than any of the other options. Because individual rights and liberties were not top of their mind compared to the others when they were calling the Constitutional Convention. The next question is, which of the following best describes the reasoning in Baker v. Carr, 1961? A, unequal representation of citizens in legislative districts is unconstitutional and may be reviewed by the courts. B, political issues such as reapportionment, redistricting, and gerrymandering are to be resolved by the legislative branch. C, racial gerrymandering is a violation of the Fourth Amendment's exclusionary clause. Or D, gerrymandering that favors a single party is not subject to legal action because there is no standard to determine how a state legislative redistrict map should be drawn. I'm seeing a lot of A's. Yeah, pretty much almost all A's. So, unequal representation of citizens in legislative districts is unconstitutional and may be reviewed by the courts. You guys are all correct. Baker v. Carr, remember the urban versus rural difference in representation. So that is the most accurate and the best answer. Next question is, which of the following is an accurate comparison of the arguments made in the Federalist 10 and Brutus 1? So remember, Federalist 10, factions. I hope I did not reveal the answer. I'm seeing lots of B's. You guys are all correct. The next question is, in Brown v. Board of Education of Topeka, the Supreme Court established which of the following principles? A school official can search a student. Wait, hold on. Oh, sorry. A school official can search a student for drugs. Hold on. Wait. Oh, sorry. Oh my gosh. Okay. A school official can search a student for drugs. B. Everyone must go to school at least until the age of 16. C. Desire to promote trade among the states. D. Separation of students by race, even in equally good schools, is unconstitutional. A moment of silent prayer at the beginning of the school day is allowable under the First Amendment. And D, yeah, you guys are all right. Brown v. Board. Segregation is unconstitutional. In Federalist number 10, James Madison argued that factions in a republic are A, a more serious threat if the republic is large, B, natural but controllable by institutions, C, not likely to occur if people are honest, D, prevented by majority rule, or E, prevented by free elections. I see a lot of B. Yes, you guys are all correct. Next question. Which of the following is one of the central concerns of the First Amendment? A, the supremacy of the national over the state government. B, the right of citizens to bear arms. C, the division of powers among the three branches of government. D, the right of citizens to petition the government for redress of grievances. Or E, the protection of the rights of those accused by committing a crime. I see a lot of, yeah. You guys are actually right. Because that was one of the main reasons why they left England and the West to build a democracy. Because the right of citizens, well, to petition the government and to give the government some kind of accountability, won't force them to take accountability. In Marbury versus Madison, 1803, the Supreme Court assumed the power to A, decide whether internal congressional procedures are constitutional. B, advise Congress on the constitutionality of a proposed law. C, regulate slavery. D, decide on the constitutionality of a law or an executive action. Or E, approve executive agreements. Yes, D, because it's establishing judicial review. The second bank. Oh, hold on, it's not one. Yeah. Oh, yeah. Sorry, this is my problem because I mixed up McCulloch v. Maryland and Marbury versus Madison a lot. But yeah. In McCulloch v. Maryland, the Supreme Court established which of the following principles? A, states cannot interfere with or tax the legitimate activities of the federal government. B, the judicial branch cannot intervene in political disputes between the president and Congress. C, the Federal Bill of Rights places no limitations on the states. D, the federal government has the power to regulate commerce. Or E, it is within the judiciary's authority to interpret the Constitution. A, yes. That states cannot interfere or tax the legitimate activities of the federal government. Supremacy clause, when it comes to federal and state governments butting heads, federal government supersedes the state governments. And next up, we have our Cram Quiz. Oh, I'm still screen sharing. Hold on. Oh yeah, actually we could go to break time because we already started this when we were dealing with the the struggles with tech. So we'll go on to break time. Hold on, let me go back. This is like, sorry, I'm having so much trouble with this. Yeah, go on.
All right, guys, so we are going to go on to Unit 1. Just give us like a quick minute to get the slides up.
Can everyone see the screen? My computer is glitching like oddly. Okay, great. So everyone can see. Okay. So we're gonna do a few questions from the Cram Quiz before we move on to Unit 1. Okay, I'm gonna fail the answer in 3, 2, 1. Exactly. So the main issue with significant element of the Articles of Confederation was the lack of an executive branch or like a central government that was able to enforce laws, tax the states, etc. Next question. Which of these is the major issues faced under the Articles of Confederation? I kind of said it already, but all right, reveal the answer in 3, 2, 1. Yes, you guys got this. The central government lacked power to impose taxes. Next question. Which was one consequence when each state retained sovereignty and independence under the article? All right, revealing the answer. Exactly. The lack of a unified foreign policy complicated negotiations with other nations. It's not D. Each state does have its own constitution, but obviously it's state, so it's not a national constitution. What amendment established protections against unreasonable searches and seizures? Okay, I'm about to reveal the answer. Yes, Fourth Amendment. Next question. What is the main concern expressed by Brutus I about the proposed constitution? Okay, I'm about to reveal the answer. Okay. It would create a national government too powerful for the state to control. Yes. So the issue of federalism and the fear that this a government of the federal government would have too much power. Oh, wait, hold on. It's between B and C. It would undermine individual liberty and freedom. Someone said in the chat, guys, remember it wouldn't be B because Brutus focuses on the government more than the people, which is true. I do see why people would say B though, why like that was majority, because having too strong of a central government or like federal government could overpower individual rights. But I think it's more about government versus state rights and how, I mean, like, yeah. Next question is, what is the main argument presented by James Madison in Federalist Number 10? Okay, I'm about to reveal the answer. Yes. Yeah, 83. Okay, that's great. The danger of factions can be mitigated in a large republic. So that's going to be our last question because we still have to cover Unit 1. So I'm going to stop sharing my screen and pass it over to my other student hosts. Thank you all.
Hi everyone.
Can you guys see the screen? Okay, until Sandra comes back, I'll take over for a bit. So hi guys, I'm Kayla, and I'll share my video right now. Okay, hi. Okay, so for Unit 1, we're going to go over the foundations of American democracy, which is 15 to 22% of our exam. So ideals of democracy. So the main ideals of the democracy were inspired by the Enlightenment, which started over in Europe within like the 1600s, and then their ideals and principles later transferred over here. So here are the Enlightenment ideas that we're going to go over. So we're basically born with certain rights, and this includes life, liberty, and property. And this was all based on the ideas of Thomas Hobbes and John Locke. So they believe in the state of nature. Basically, it was before like there was a civilized government involved. People were poor, nasty, brutish, and really bad. And so this translated into making it seem that Locke's ideas were more positive. And Locke's ideas, of course, were life, liberty, and property. So popular sovereignty, basically, is the idea that people hold the power of the government. Oh, it says that there's a lag. Can you guys hear me now? Is everything okay? Okay, just making sure. So back to popular sovereignty. So popular sovereignty is the idea that people hold the power of the government. And so another Enlightenment idea is the idea of the social contract. It basically that in order for the government to operate, some of the people have to hand over some of their power or some of their liberties. And so basically, if the government does not protect these rights, then the people can overthrow it. So republicanism, what is republicanism? So it's Baron de Montesquieu's ideas, and basically the idea that leaders are elected by the people in order to represent them. And also, it's the idea that not only should this power go to the government for the people, but it also should be separated into the executive, legislative, and judicial branches. So more ideals. And so these ideals then translated into the Declaration of Independence, which we know is like the breakup letter of the documents. It talks about natural rights, people having rights to life, liberty, and the pursuit of happiness. They said the pursuit of happiness, not property, because back then not everybody had access to property because there was enslaved peoples. And so we also have the social contract, the idea that to secure rights, governments had to be an institute among men, aka meaning that governments were created to protect natural rights. Back to the idea of popular sovereignty, basically governments are deriving their powers from the consent of the governed or the people. We can also talk about the Constitution here and the separation of power between the executive, legislative, and judicial branches, and each of those branches have powers that check one another's. And then also the idea of republicanism again, basically representative republic, where everybody votes for representatives to represent their best interest within the government. So the different types of democracy. So we have, is the audio glitchy for you guys? I just want to make sure that you guys are hearing me correctly. Okay, so you guys can still hear me. So there's three types of democracy that we're going to go over. The first one being participatory, meaning that there's these groups of citizens or voters that are voting on laws directly without representatives. And they're also doing this in through initiatives. People are proposing laws that they want, and referendums, people rejecting the legislators' laws without a vote. And then we have pluralist democracy. There's different groups who compete to make policies. There's interest groups also factor into this. They focus on a certain cause and raise money to persuade legislatures for laws. And states are also groups that represent the interests of citizens. Then our last one, we have elite democracy. There's a small group of wealthy, highly educated people who make the laws, and they're in charge of governing the whole region, per se. The argument is that this specialized or educated people should be used to make good decisions. And so basically an example of this would be the president appointing judges and the electoral college. And so some of the examples of like the democracy within the different documents that we've talked about. In Brutus number 1, we see that they support a participatory democracy and with the power within the states in order to prevent tyranny. The Anti-Federalists were against the idea of any centralized government because of tyranny. So that was their main argument within Brutus number 1. In the Constitution, we talked about the states having to compromise in order to pass legislation, which is a good example of elitist democracy describes, like, for example, in the Constitution, there's a small group of elected representatives who make laws for citizens. So direct democracy versus representative democracy. So like I said before, representative democracy is basically the people, they vote for elected representatives, and then in turn, those elected representatives help with the laws, the rules, and like setting the foundation of laws for the governed and the government itself. And then direct democracy, you have the people, they vote directly on laws and rules. And then government power and individual rights. So basically, the Constitution manages the tension between the authority and the liberty by establishing a system of checks and balances, basically making sure that one specific branch doesn't have too much power over all the other branches. So like I said, no one branch has too much power. Federalist 10 talks about how citizens have the right to oppose interests of a community, basically talking about factions. Brutus number 1 argues against the ratification of the Constitution for it because they believe it represents a threat to rights, but then that ended up getting resolved through the Bill of Rights, basically stating out what liberties do we have as citizens and what the government can't encroach upon. And so the Ninth Amendment specifically like we just went over, specifically talks about protecting individual rights that aren't directly listed within the Constitution. So, in terms of the Articles of Confederation, right? We talked about how there's a lot of weaknesses to them, and that's exactly why we had to move on in terms of creating a new founding document for our country. And so the weaknesses, of course, were the centralized military, lack of centralized military, which really led to us addressing the Shays Rebellion. There wasn't a centralized military to really help that out. There was no executive branch to enforce laws or into like a unifying tax for the whole country. There wasn't a national court system. We couldn't check if laws were constitutional or not. And there was no power to coin money, no power of the purse, essentially. And so this caused a lot of issues in terms of interstate trade because there wasn't a mediator in the situation, like a central government. And another example of the weaknesses within the Article of Confederation is the Slaves Rebellion, like we just talked about. It really showed the weakness of the Articles of Confederation. And so, like I said, there wasn't a federal government to mediate. So this event really led to our country's Confederation to establishing the Constitution. So the ratification of the Constitution. So some notable figures who wrote the Federalist Papers would be John Adams, Alexander Hamilton, Thomas Jefferson, and James Madison. Some of their arguments were that federal courts had limited jurisdiction, and so that left a lot of the areas of the law to local courts, and then the local courts would have different interpretations. There wasn't a national interpretation of specific laws, which caused a lot of issues. The Anti-Federalists, notable figures would be Samuel Adams, James Monroe, George Mason, and Patrick Henry, and they favored local government, arguing that centralized government would become weak over time. They were scared of tyranny, and so that's why they wrote Brutus #1. They were scared that these powers that the states now had would then be taken away by the government. So the Federalist Papers. So the purpose was essentially like they're written after the Constitutional Convention, and they were trying to convince Americans to support the ratification of the Constitution and for basically to have a strong federal government. And so what compromises were made in order to get the Constitution ratified, right? So we have the Great Compromise, which is really important for you guys to know, basically led to the creation of the bicameral legislatures through the House and Senate. You have the Electoral College, which is a process by which the U.S. selects a president. You have the Bill of Rights, which we just went over, the first 10 amendments. We have the 3/5 Compromise, which determined like if slaves were counted in terms of elections, which you had the 3/5 Compromise. It was decided in 1787 at the Constitutional Convention, and it determined that slaves were counted as 3.5 of a vote, basically. And then you also had the 1808 postponed decision, and this in turn imposed heavy penalties on international traders, but it did not end slavery. So the processes. So an article versus an amendment. So what is an article? An article is an original part of the Constitution, which basically describes how the government is to be run, right? And an example of this would be Article 5. To pass any ratification to the Constitution, it requires 2/3 of the legislature for Congress to pass it, right? And so an amendment is basically any changes that the Congress wants to make that ratifies the Constitution. So debates. So there's been a lot of debates on the role of the national government, the powers of the state governments, and the individual rights that we have. And so in terms of the role of the national government, we have basically the debate on the foundational to the functioning of democracy, the distribution of governmental power. And we saw that Federalists and Anti-Federalists were constantly going at this about like how important is a strong central government in order for America to survive. We also had the debate over the powers of state governments. Should they have the power to establish local governments, issuing licenses and conducting elections, and then ratifying amendments, and then supporting citizens' health and safety, and then creating a state constitution. And this is basically what the Anti-Federalists fought for. They wanted to maintain states' rights. And so we see now that there is kind of a separation of what the government is allowed to do and what state governments themselves are allowed to do in order to conduct business and to make sure to basically serve their governed. And then we have the rights of the individuals. The Ninth Amendment basically, like I said before, protects the rights that are not specifically listed in the Constitution. So, principles that were shaping the American government, right? So we basically went over all of them. This is a summary. So separation of power, this is discussed in Federalist 70 and 78. It's basically a division among branches and to prevent tyranny. And then we have like basically coincided with that is the checks and balances, which are basically mechanisms to make sure that one single branch doesn't hold all the power and abuse that power as well. And then we had basically Federalist 51 describes both the separation of power and checks and balances. And then federalism, basically the allocation of power between state and federal governments, basically who gets the finals, which the federal law is like basically above the state law. And so even though the federal law is above the state law, we still have different powers within each state. And then we have the idea of republicanism, the role of the citizen participation in government incorporates virtues within government. So the relationship between the state and national government. So exclusive powers are powers that are reserved to the federal government or to the states. And so that includes enumerated powers, implied powers, and the necessary and proper clauses. So reserved powers are not specifically granted to the federal government by the Constitution. Republicanism, Ethan, going back to republicanism. Republic, basically we're a democratic republic, but republic refers to establishing a representative. So basically that is the representative is the mouthpiece of what the people want, basically. So citizen participation refers to basically civil service, basically voting. So that refers to republicanism. Sorry, it's technological difficulties. So going back to the relationship between the state and national government. So like I went over exclusive powers. So going back to reserve powers. Reserve powers are not specifically granted to the federal government by the Constitution. And this example of this is the 10th Amendment. The 10th Amendment was created specifically to reserve powers that weren't included within the Constitution to the states, basically, like running elections, creating marriage laws, and regulating their school districts within the state. And then you have concurrent powers. Concurrent powers are powers that are shared by both the federal government and the states. And that includes the power to tax, to build roads, and to create lower courts. It also has the power, they both have the power to create amendments to their constitutions as well. So fiscal federalism, right? So we describe federalism as like the allocation of powers between the state and the federal government. And so fiscal federalism refers to the influence of federal funds on state policies through grants, block grants, categorical grants, and mandates. And so grants and block grants and categorical grants and mandates are basically money that the federal government may give to the states in order to get them to support a different component of their ideology in terms of like them wanting to build more roads or for any other reason. I know that's a bad example, but like just to give you an idea of what those grants are going towards. And so in recent trends in federalism, we see that there's a shift towards more state autonomy in certain policy areas. Basically that the states are kind of like deciding on their own and kind of overriding the federal government in terms of what the president may believe or what the Congress may believe. They're doing what they think is in their best interest as a state. So an example of this is marijuana, and most recently and controversially, abortion. So there's a variety of constitutional interpretations of federalism. The first one we have is the selective incorporation, basically the selective application of the Bill of Rights, due process, and the equal protection clause of the Fourth Amendment. Basically, the Fourth Amendment states that was created in order to protect slaves that after the Civil War, to make sure that they were included in the American citizenship, basically, and they received their all the benefits of being an American citizen. Basically, even though that they had been formerly enslaved. You had the Supremacy Clause as well, which established that the federal constitution and laws supersede state constitutions and laws, basically, that no matter what the states may say, unless it's pertaining to that state specifically, the federal law will always be here and the state one will always be here. Basically, the federal law always overrides state law in some aspects. We also have the Commerce Clause, which gives Congress power to regulate interstate commerce. An example of this is U.S. v. Lopez. I saw that this was a really popular case in the chat, so we'll get to that in a moment. But there's a necessary proper clause as well, and that allows Congress the ability to make laws or to act where the Constitution doesn't normally give it the authority to act. So yeah, those are the constitutional interpretations. So a case with the Commerce Clause, please, is U.S. v. Lopez, 1995. Okay, so basically the whole, so basically the whole case was about gun possession, and this case basically established for the federal government can't prohibit it. So basically that was an instance where the federal government enacted the Commerce Clause. So interpreting the Constitution's necessary proper clause that we just went over, right? And so to give you like a brief overview of what the clause is talking about, it talks about the grants that basically grants Congress, the power to act or make laws without authority from the Constitution, right? And so there's various debates on that, and so there's two interpretations that we can use to describe this, which is basically the loose constructionism, a loose interpretation of the Constitution, basically is to typically expand federal power, and then you have the strict constructionism, which is basically a direct interpretation of the Constitution, which basically seeks to limit federal power. So, a case with the necessary and proper clause. McCulloch v. Maryland in 1819. This is one of the main cases that you guys should know. Without going into it too much, to give you like what the decision was, the federal government basically ruled that the federal government has basically the right and power to federal bank, in which they did, and basically also they really made this really clear that states did not have the power to tax the federal government, as the federal government was over them. So that's really important to know. Federalism in action. So this happened recently, and it was the overturning of Roe v. Wade. And this demonstrates federalism in action because it basically allowed each state to set its own policy on abortion. There wasn't a federal law that said what to do about abortion. It was just left up to the states. The same thing with legalization of marijuana. You basically there's no federal law with it, basically allows states to set its own policy and regulations. And also with election laws, so election laws actually limit the ability of the majorities within some states to create state laws, which allows for freedom in voting as well. So we kind of have a little bit of break from like me just talking a lot, and I actually want to hear from you guys on this one in terms of our discussion questions. So our first discussion question is, how do principles of federalism, basically what we just went over, manifest in contemporary policy debates? And hint, hint, we just talked about it. So I want to hear from you guys. I'm going to give you a few seconds to enter it into the chat. Yeah, an example is abortion. Exactly. Basically, you guys are getting it. For our second question, we talk about what are the key arguments made by the Anti-Federalists against the ratification of the Constitution. I think this is a really easy one. So again, I'm gonna give you guys a few seconds and see what you guys come up with. So the question again was, what are the key arguments made? Oh, sorry, just all came in. Sorry. Yeah. So you guys all got it right. So they were scared that basically the states wouldn't have as much power as they had before, and that the federal government would encroach on their rights, which also ended up leading to the implementation of the Bill of Rights. Yeah, basically lacking a Bill of Rights, and we ended up getting that Bill of Rights, which we have today. So our final discussion question before we move on to some MCQs is, in what ways does the separation of powers function to maintain governmental integrity? Yeah, prevents tyranny, checks and balances. Yeah, and infringing on on individual rights. So yeah, you guys are right, and so congratulations. Would any of my co-hosts like to take over for the MCQs?
Sure. I don't know if anyone else wants to. I know you guys haven't heard from Danny a lot. Danny, do you think that you can take this over? All right, no worries. Okay, so I guess me and Kayla can do the section. So guys, this is an example of a passage-based MCQ that you'll have. So they give you like a small blurb, and then you'll have some questions, either like one or two, to go off of based on this. So we'll give you guys like, what do you say, like 2 minutes to answer this question?
Yeah.
You think it's fine? All right, so read the thing, read the question, and then if you've read it close enough, you should be able to deduce and find the answer.
I see a lot of C's in the chat right now.
Now will be you guys 1 more minute. It's actually a couple seconds, actually, maybe.
Yeah, I think that a lot of people have gotten C, so let's check to see what the correct answer is. And the correct answer is C. Round of applause for you guys. Good job. Good job. You guys do know this. Don't worry. You guys got this. You guys are going to be okay.
And just for you guys who might not have gotten the answer, so like Danny said in the chat, these questions emphasize definitions. So look to the question. So the question is trying to ask you, it's not talking about like what you know particularly, it's saying which of the following choices captures the author's argument, right, about democracy. So if we read the blurb, right, the author is, talking that a groupist theory conceals the most significant aspects of the system. Plural's heaven is the heavenly chorus sings with a strong upper class accent. 90% of people, yada, 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 system skewed, loaded, and all that. So once you get through all of those details, and then you see that the question's asking about the author's argument, the answer choices you should be looking for, the one choice you should actually be looking for is the one that follows sort of, I guess, like the thinking or so of the author, not so much of what exactly is democracy or a form of democracy, more of what is the author saying about different forms of democracy. And yes, Angelina, yes.
I was seeing in the chat that
choices first, yeah.
I was seeing in the chat that you guys may need a little more time, so on the next one, we'll give you a bit more time. Sorry. Okay. So, same passage and then just basically answering the question now. A lot of C's in the chat. So drum roll, please. C, you got it correct. Round of applause. Okay, next question. So same passage, and you'll see a lot of this on the AP exam. Same passage, just different questions. And so now answer this question. I'm seeing some B's. Oh, C.
It's extra. Okay.
Yeah. Oh, there's a variety of answers.
Okay.
Some contention here. Let's see. And the answer is D. The answer is D. And so it says basically here, which of the following activities would the author most likely be concerned about interest groups engaging in? Basically forming iron triangles within the bureaucratic agencies and congressional committees. So this is also basically just a straightforward question.
Oh wait, we might want, sorry, we might want to explain the answer for the last question. Just because I saw some questions about like what an iron triangle is and everything else.
Well, that's one of my weaknesses. Amara, would you like to take that on?
Sure. So I also had a weakness in iron triangles for a little bit, but from what I remember, and you guys can always correct me if I'm wrong, is that an iron triangle is basically a relationship between you have the bureaucratic agencies, all right? And this is like, I don't know one off the top of my head anymore, but yeah, it's a relationship between the bureaucratic agency and interest group, which you could think of as, really can't think of any interest group out. NRA is an interest
Yeah,
group. You
all
can
right.
think of it like that. And then you have a congressional committee, all right? So a congressional committee that has to do with like Second Amendment, gun laws, things like that, all right?
Yeah.
So that iron triangle basically shows the relationship. And this basically says that the interest group will give political support to the congressional committee, all right? That's one thing. And in return, the congressional committee is going to, have friendly oversight over that interest group. So if the NRI is about like, Second Amendment, right? And they're like, okay, we're going to support this committee, but in return, we want support from you within, the chambers of like Congress and everything else. So that's one relationship. And then you have another relationship between congressional committees and the bureaucratic agencies, where the committees will give out funding to the agencies, and the agencies will sort of like make policy choices and executions that follow the committee. And then between the agencies and the interest group, it's that the agencies won't regulate as much to that interest group, so they won't like regulate against it as much. So they'll be like very much for the NRA, for whatever like agency that is, and then the NRA in return is going to lobby their interests and of the agency. So it's like between all three of them, nothing really gets in between. They're all giving and taking away from their relationship. So in this question, with the sentence that the notion that the pressure system is automatically representative of the whole community is a myth fostered by the universalizing tendency of modern group theories. And then just going on by like the next two sentences, the idea of an iron triangle is really there because within that, no other like, thing can really get into that. So I hope that makes sense.
Exactly. Going on to the next question. So about the Articles on Confederation. Unlike the Articles of Confederation, the Constitution does which of the following? Restricts the ability of Congress to tax, restricts the ability of Congress to establish an army or navy, establishes a unitary form of government, emphasizes state sovereignty over national sovereignty, or emphasizes both national sovereignty and federalism. Seeing a lot of E's. All right, let's see. Yeah, E. You guys all got this one. Round of applause. And so basically it enacts federalism because there's two different separate levels of government, and also national sovereignty. Basically the people help govern in a way that like they give some power to the representatives, who then help negotiate in terms of their what the policies they want to enact. And also we will slow down. Okay, so which of the following best defines the constitutional interpretation of federalism? So is it A, the federal government and the states each have separate and mutually exclusive roles and responsibility? Basically, neither controls the other. Or B, the states have some powers reserved to them, which they may exercise if the Supreme Court permits. C, the federal government and the states have separate but overlapping powers where these powers conflict. The federal government prevails. The states may only exercise those powers delegated to them by Congress. Or E, the federal government may exercise only those powers specifically enumerated in the Constitution. And so I'm seeing a lot of C's in the chat. I'm going to give it one more second or so, just so everybody has the chance to read them and look through it. All right, we good? I think we're good. All right. And the answer is C. Yeah, so going back to when these powers conflict, we talked about the Supremacy Clause. The federal government always prevails, but they do have separate but overlapping powers. Sorry. So this question asks, basically, the congressional power that has been contested most frequently in the federal courts is the power to A, establish post offices, B, coin money, C, levy taxes, D, regulate commerce with foreign nations, or E, regulate interstate commerce. And I'll give you guys a second to ponder upon that.
I'm seeing a mix of answers.
Okay, so the answer, states want control of basically how they can monetize their imports and their exports, and so they kind of want control over that whole thing. They kind of don't want the federal government kind of reaching over and controlling that. So it's been one of the most contested. So another question is, concurrent powers have which of the following effects on the United States political system? So A, they reinforce the expansion of the power of the national government and the supremacy of the national law. B, they eliminate disputes between the states and the national government by creating completely separate pieces of influence. C, they foster cooperation between the states and the national government by requiring that two levels of government work together. Or D, they make it possible for the states and the national government to simultaneously exercise influence in the same area. So I'm seeing a bit of mixed answers. I'm seeing both C and D right now. Give you guys 3 more seconds to answer if you haven't already. All right, I think we're good to go. And the answer for this one is D. Basically, concurrent powers make it possible for the state and the national government to basically simultaneously exercise influence of the same areas of public policy. Basically, they both are able to exercise within the jurisdiction, and the states are technically a part of federal jurisdiction together, but state governments are allowed to exercise what they perceive to be in the best interest of the governed, while between the states and the states.
So the problem with C is that it's not necessarily, sorry, can you go back just one?
Yeah.
So the problem with C is that it's talking about requiring that the two levels work together. Concurrent powers don't require both of them to work together. It basically is almost saying like, if there ever comes an opportunity where they both have need to exercise influence in that same area, it is possible. It's not required that they have to, because there are other ways to do that, but with concurrent powers, it's possible. So C is more like solidifying that and saying it's a requirement when in fact it's not a requirement. So like Danny also said, vocabulary is very important. So look at like certain words. So with concurrent powers, don't think requirement, think more of like option, I guess, if that's any easier.
Yeah, that's a great point. So for the next question, it basically asks, which of the following is a fundamental element of the U.S. U.S. Constitution? Sorry. A, recognition of the centrality of political parties in the government. B, direct election of members of the executive branch. C, an executive branch that is more powerful than legislature. D, emphasis on a unitary system of government. Or E, division of government authority across political institutions. And like Danny said, think about which of these answers are actually within the Constitution. We're going to give it a few more seconds. I'm seeing a lot of people go with E. Some of the people are backtracking and that chose D. Ended up going with E. Yeah, the Jeopardy tune. We should play that more often. And the answer is E. You guys were correct. The division of government authority across political institutions. Like we discussed, there's a separation of power and there's checks and balances of power, so the executive branch can't be more powerful than the legislature. We aren't in a unitary system of government. That's if you're ever interested in that, that basically means that the executive is a part of the Congress as well. So that's a whole other issue. So no, we are not a part of a unitary system of government. But yeah, good job, everybody. And so for this question, it basically asks, which of the following best defines the constitutional interpretation of federalism, right? Which these powers conflict, the government prevails, they exercise those powers delegate. There's a lot of answers already coming in. D, the states may only exercise those powers delegated to them by Congress. And E, the federal government may exercise only those powers specifically enumerated in the Constitution. And the answer is C. Yeah, I do think this may have been a repeat question, but it's good for review. So for this question, it says the procedure for formally amending the U.S. Constitution best illustrates which of the following? You have A, the dominance of the national government over the state governments. The B, the dominance of the state governments over the national governments. C, the founding fathers' desire to facilitate rapid constitutional revisions. D, the Supreme Court's power to review constitutional amendments. E, the federal structure of the U.S. government. Let's see, some answers are coming in. I see E's, I see some C's. Give it a few more seconds. And the answer is, drumroll, E. Yeah, basically demonstrate the federal structure of United States government. They kind of make it really hard to oh, sorry, I cut out. But yeah, this basically demonstrates the federal structure of the U.S. government. We already had a break and we're about to end, so sorry. We'll skip over that. We already had a break. We already did, basically, I don't think we have enough time for a practice quiz.
All right, so I believe Kayla cut out, but there is a survey link that Kate just posted in the chat. Thank you very much. That you guys should fill out right now, or if you have the time, even after this live stream ends. It'll just help us, get a really nice idea of how we did and how you guys really liked it and what we should focus on more. So go check it out. And we want to thank you guys so much first for your patience for like those first 30 minutes. And really just you guys have been amazing tonight. So thank you so much. So be sure to check out the survey and to take it. And so if you guys have any lingering questions either about Unit 0 or Unit 1, ask away and we'll try our best to answer them.
Oh, thank you guys so much for coming. We appreciate, I'm sorry I cut out a little bit, but thank you so much for attending. We hope that you come to our next session, which is tomorrow at the same time, same place. Hopefully Crowdcast starts working again. But we thank you so much for participating. We hope you guys learned something. If you have any questions, you can still ask them in the chat. Hi guys, I'm back. Are there any more questions for us hosts?
It doesn't look like we have any more questions. Right.